I'm here with Ryan Pankoe. Ryan, just got to meet you for the first time in person today. I heard about your case, and yours is dealing with the no-fault divorce issue in Pennsylvania. Do you want to say anything about it first?
Well, certainly, what I'm challenging is that the no-fault divorce statute is the Pennsylvania 3301D statute.
Okay.
And
are you challenging it as being unconstitutional, or
yes.
Okay? Tell me a little bit more about that. Why are you making this argument?
Well, so the way that it is now, the statute itself, it actually has the judge in a position to make a ministerial decision, because the plaintiff being my wife in the case, she's the decision maker in this, and the judge is not making a judicial decision in a judicial capacity.
Right. So there's no separation of powers, and actually the judge has no authority to the judge is supposed to make a judicial decision,
yes.
Not just enforce a decision. That's a different branch of government.
Yeah, the statute itself doesn't actually prescribe any right, duty, or obligation for the judge or the courts to uphold.
Okay.
There's no enforceability under the statute because there's no right, duty, or obligation prescribed.
Okay.
It's because of the single subject clause in the law. A law itself must actually only enforce one particular grievance.
Right. So in other words, the plaintiff always wins, guaranteed.
Yeah, 100% of the time.
100% of the time.
In fact, in a hearing before the judge, I actually asked her that question. I said, has there ever been any time that it has been ruled in favor of the defendant? And she couldn't provide an answer to that.
And this is what I've talked about many times, is that it's the same thing in the state of Texas. The state always takes the side of the person filing for divorce without exception, and it's very easy to prove. Go back over the last 5 years and show me 3 cases in which the judge said, no, I'm not granting the divorce. The person who wants a divorce for any reason, for no reason, no evidence is necessary. It can just be that, well, I'm not happy right now. Happiness is not a reason to dissolve a legal institution. 2 people got married. You had to get a license from the state.
Yes.
And the state recognized your union by conferring upon you a different legal status. You went from single to married. And at least in our state, we look at the family as being the entity, the best entity, the institution for children to be brought up in, for the rearing of children. We don't want to have a whole lot of orphan children running around. We don't want to have fatherless children or motherless children. The state recognizes that the best interest of the child, and I'm saying the best interest of the child because everybody invokes the best interest of the child. The best interest of the child is to be raised in an intact family with his or her or their natural father and natural mother, period, in almost every single instance. There may be a few instances, the vast minority where that's not the case, but if you have 2 parents, that there's no charge of any type of abuse or sexual molestation or abandonment or any type of fault-based something that you say that person's a danger to the children, the state recognizes that the best place for a child is to be in a home with a natural mother and father. And yet, at the very same time, in our divorce courts, the one person unilaterally, without the consent of the other person, can say, I want to destroy this legal entity, this legal institution. I want to change my husband's status or my wife's status from married to legal. I want to take the kids. I want to get child support. I want to deprive him or her of everyday interaction with their children. And the judge, without exception, always grants a divorce. So there's really no type of judicial decision being exercised. The judge is not acting in a judicial capacity and therefore is violating his or her sworn obligation and duty. There's got to be some type of findings. There's got to be some type of findings of fact upon which a judge will make a decision. Yes, there were these things that happened or whatever, and therefore, based on our law, we say a divorce is a remedy. But what's happening with no-fault divorce is that no evidence is necessary, no fault is necessary, and the judge will step in and completely terminate, erase and change a person's legal status, deprive a child or children of everyday access to both parents. It's horrendous what goes on. And I'm glad you're making the constitutional challenge, because it needs to be done.
Yeah, they're taking civil actions on the, in my case, on me as a defendant. They're making civil actions. They can make you pay something in, child support. They can make you, they can take away everyday access to your children, all without ever finding fault in you at all.
Right.
And never being accused of anything.
Right.
Constitutionally, you're to know what you're being accused of, and that's not happening.
Now, I want to take this a little bit further with you. It looks like you're a Christian. I see that you're wearing the cross and everything. Were you married in the church?
Yes, sir.
You both looked at your marriage as being a commitment, a vow to God first?
Yes.
Lifelong? You didn't say, you know what, we're just going to get married for 5 years and then call it quits apart?
No.
So you actually had a religious commitment within a church. It was done by a minister?
Yes.
And it was done in front of many witnesses, or at least some witnesses?
Yes.
So you had a whole ceremony, and you probably had to apply for the license first so that you could do this. Had to be a minister. It had, all of these specific things that were taking place. I'm sure that, probably during the ceremony, the pastor probably gave a charge from Scripture, talked about the institution of marriage, why God created marriage, not the state, by the way. God created marriage. So you looked at this as being a religious commitment.
Yes.
And it was not just a religious commitment that was a temporary thing. It was a lifelong religious commitment.
Yes.
And here you have a judge, a person acting as a judge, because as we've said, he or she is not actually doing any type of judicial
not acting in a judicial capacity.
Right. As an agent for the state, violating and destroying the institution of the church. Is there a religious liberty issue here?
Oh, absolutely. I think that there is. Unfortunately, as it was made very clear to me we had met with a divorce master and had a hearing before a divorce master, and was made very clear to me that none of that matters. It's strictly based on the statute and the laws that they have to abide by. They don't want to hear any religious argument. In fact, I made it clear in a hearing before the judge that my challenges on this in the courts, while I have many religious reasons for opposing what's going on, I said my arguments in my motion for summary judgment that I filed are strictly based on matters that are legal matters.
Right, and that's a very important point, because you're right. It's complete deprivation of due process, of equal protection under the law. You can look at it under contract law. I look at it, the ways that I've been trying to argue it is, yes, I believe as a Christian that marriage is a lifelong commitment. But in our society, because we have abandoned a lot of our Christian underpinnings, we still can make the constitutional argument. And constitutionally, it is absolutely horrendous what's going on. You lose your constitutional rights. And what they're actually doing at the same time, they're making a parent, they're depriving him or her of being a full-time parent. Parenting, being a parent, the parent-child relationship is one of the most sacred, fundamental rights, even ruled by the Supreme Court, that we possess. And here is a person that basically says, you can now be a part-time parent, or a visiting parent, or maybe an every other weekend parent. It's horrendous what they're doing.